Welcome to another in the series of NJAPM webinars. I'm Cangelosi, and today we have an interview with Hanan Isaacs. Hanan is a mediator, arbitrator, and trial lawyer with offices in Kingston, New Jersey. He's a past president of NJAPM and a past chair of the Dispute Resolution Section of the New Jersey State Bar Association, where he was the recipient of the Section's 1999 ADR Practitioner of the Year Award. His law practice emphasizes employment litigation, business litigation, personal injury law, family law, and ADR in those fields. Welcome, Hanan.
Thank you, Carl. Happy to be here.
Great. So, first question. You're a mediator.
Yes.
Why did you title your presentation as Employment Mediation from a Trial Lawyer's Perspective?
I created that title, Carl, because I wanted what I have to say to be of relevance to people who are mediating employment type disputes in New Jersey or who are considering it. And I thought it would be best, instead of saying, as a mediator, here's what I do, to look at it from the perspective of one of the trial counsel who is basically a customer in the mediation process, or at least representing one.
Okay. I should have mentioned at the very beginning, as sort of instructions to those people viewing, that there will be question and answer time. And so if people could go to the bottom of their screen, just put the mouse at the bottom of their screen, they'll see a chat box, a chat menu on the menu. So if you click on that chat, you can enter, type a question in, click enter, and then we will see the questions. I'll ask Hanan about halfway into the presentation to answer some of them, and then others at the end. Okay. So do you both mediate and litigate employment matters?
I do. I will say a lot of the mediation I've done was more maybe 15 years ago or so, because I was getting involved with cases referred by the Equal Employment Opportunity Commission's Newark office. And so I went through their training in addition to the NJAPM and other training I've done in family law, family matters, to get specialized training for mediation of employment matters, and sat with more experienced mediators in that setting, and also did some of my own. And I've gotten, over the years, private referrals in the employment law or employment dispute area to mediate. So I have done that historically more than currently. Mostly now, which is another reason I wanted to do this program with you, my experience in mediation is actually taking clients to mediation in the employment law field.
Okay. So are you still on the court's roster for civil matters?
I'm not. I did that work between 1995 and 2005. And I decided at that point, the system was not moving in the direction that I wanted it to, which was full compensation of mediation professionals from the first minute. And the more I saw that not happening, the more I realized that my way of registering a protest was just to get off all of the court lists, which I have done. So any mediation I do now is purely from private referrals.
Okay, I dropped off at about the same time for the same reason. So when do employment matters generally go to mediation?
In my experience, and I've been doing employment law representation for about 20 years. So it's about half of my practice experience. What I've learned in that period is that really at least one party, or possibly both, will take a good look at the possibility of mediation pre-filing and say, we've got this matter, it's heading towards litigation. Is there any way that your team or our team might consider kind of a diversionary plan to just keep it out of litigation entirely. Now, that does not happen often. It does happen, and it's important for people to know that. It's actually a very smart move, the same way that in the family arena, in divorce mediation, it's probably the best thing you could do when the people are getting along, maybe not well, but certainly better than they would if they go to litigation. It's saying, how can we do problem solving? How can we exchange information, informally, rather than go through an expensive and, sort of wall-to-wall discovery process. So one of them is definitely the dispute is there, but nobody has filed anything. And the second major time, of course, is going to be once there is a case in court, whether it's federal or state. Again, one party or the other is going to say relatively soon, after the issue has been joined, meaning both sides have filed their pleadings. Do you have any appetite to sit with a professional and try to get these issues ironed out before the big money has been spent? That's not an unreasonable question, but for some litigation people, the attorneys, they may feel it is too soon. Now, some of that could be good faith. Well, if it is good faith, you can always talk to the mediator about that, managing the discovery process after the case has been filed. And in some cases, I find it's not such good faith. And you're generally more likely to get that from the defense side, which is being paid hourly, than the plaintiff side, which generally speaking is going to take this on a contingent fee and hopefully a fee shifting basis, meaning if you represent a prevailing party in an employment law matter under a civil rights cause of action, including whistleblowing, and you win, you're going to have a very strong likelihood of getting some amount of compensation from the trial judge. And there's case law about that, plenty of it, federal and state. So the plaintiff's attorney has a strong incentive to win the case. But of course, you never know at the beginning or even in the middle if you're going to. So it really has to be much more that the defense side agrees. Our client doesn't want us to pursue that difficult path. And of course, of litigation, the stronger the plaintiff's claim, the faster the other team is likely to consider mediation.
So if you're talking about pre-litigation,
yes.
Why aren't more people going to mediation? Is it because they're too angry, they don't know about it, or something else?
I think it's more institutional. Don't forget, when divorcing parties come to a mediator and say, we disagree on many things, but one thing we agree on, we don't want to get lawyers involved. We don't want the big fight. Mm-hmm. It's very easy for them to, kind of reach across that particular aisle. It's really much harder for an employee or a former employee to reach across and say to management or management's counsel, hey, why don't we mediate? So basically, the gatekeepers in that situation tend to be their legal representatives. And those people have to be persuaded. Sometimes they have to persuade each other. Occasionally, you get a defendant company that says, we've been down this road too many times. We're now enshrining it in policy. We actually give incentives for our litigation counsel to get the thing resolved at the earliest possible moment and for the least amount of what all of us as mediators should be calling transaction costs. Mm-hmm. Right? Part of the cost of doing business is how much is going to cost us to get this dispute wrapped up. Litigation is the most expensive of anything. And it rarely makes great sense to invoke it and just kind of ride that particular horse. It does sometimes where an employer feels that they're being extorted or it seems like a totally frivolous claim or a claim that they feel they can knock out in some procedural way, such as a motion for summary judgment saying to the judge, keep this case from the jury. But many, many cases will not fall under that. And you're really stuck kind of in these middle cases where they're fact sensitive. A lot of it's about credibility. So it's harder to, with great predictivity, say everything is going to mediation. Now, with that said, under the civil rules and the civil practice in New Jersey, and certainly in the federal rules, in the most cases, at some point, you're going to mediation. Somebody could come in, if the employer thinks it's a dumb case or a frivolous case or a spite case, they come in with their arms folded. There's nothing you could do about that. You just go through it, get done with it, and you're back on the litigation track. Okay. I can also say there are times that people may decide to mediate late in the case. It does happen. You could say, you've got a trial date, and the parties say, well, we've been through summary judgment, the employee beat the employer's motion. There still could be a reason to have that conversation and to try to get to common ground.
Okay, so let's say you're the attorney for one of the parties, and you're going to head to mediation. The other party agrees too. How do you pick the mediator?
It's an excellent question. It brings to mind many years ago when I was working on New Jersey policy around mediators and mediation and how high to set the bar with qualifications and diversity issues and all that. We looked at Florida, and I'm not sure the same is true in New Jersey today, but at that time, and we're going back maybe 15, 20 years, the common wisdom was that 10% of the Florida mediators were getting 90% of the Florida disputes of all kinds. And I'm going to say it's also true that a disproportionately small number of mediators in the employment law world, as well as in the family dispute world, tend, as court referred or attorney chosen, tend to go to the people that they feel have the track record to justify the trip. These are people who, at least in the employment law world, they don't want to spend a ton of money and resources in a fruitless endeavor. So it's sort of like, if we're going to go to X, we want a pretty good chance that that thing is going to settle either then or within a relatively short time after. So I do the same thing. As a trial counsel, I look at the field of mediators. I tend to look at the nature of their practice. There are people in the employment law world who tend to come from one of two places. They're either formerly very active in the defense bar for management, or they're formerly very active for the plaintiff's bar for employee/workers. Occasionally, these are individuals who have done work on both sides in different cases over the years, tending to do more for one, less for the other. And occasionally you have people who are still active in the practice of law or retired judges who are doing mediation, following whatever their career path has been, but they're still actively doing the legal part. Sometimes as trial counsel, sometimes as consulting counsel, but they're still actively practicing. And then you have the people who say, I don't want to touch anything in the litigation area for one side or the other because my credibility depends on it. I don't want people feeling like because I did this case at that time, that makes me more biased towards one or the other.
So if you're looking at these, I guess there are numbers of these mediators, and you're saying not a huge number, but a number of these employment mediators. Obviously, they're successful in getting the cases mediated, or a large number of them, or else you wouldn't be picking them. Is there any common characteristic other than they're successful? I mean, describe their styles, is there anything that, sort of across the board marks a mediator that you would pick?
This is a profound question, Carl, and a good one. The way these matters are mediated, in my opinion, is not something that I would tend to do. Right? A lot of them are very, very sort of hermetically sealed. The plaintiff and counsel go into one box at one end of the office, and the defense counsel with an HR representative and maybe one or two management people plus defense counsel are going in the other box. They don't even have a plenary initial meeting to describe what we're going to do today. It's almost that you get two separate discussions by the same mediator saying, okay, here's how it is over here, and the same thing I'm telling them over there. And essentially what you're looking at is shuttle diplomacy. Like Henry Kissinger in the Middle East would have recognized this as a style. It presumes the parties do not want to look at each other. They want no part of each other. They don't want to listen to each other. And their lawyers are following that same model. We stay in our team and they stay in theirs. And I've gotten used to it. I think that the transformative mediation world would seriously question that model. What are you doing? Especially, believe it or not, in some of these cases, especially in the federal sector, the employees are still working there. And the fact that they can't sit down with their counterparts and try to make common cause troubles me. However, a lot of those mediators are doing it that way. Now, when I conducted my mediation in EEOC and privately, and if people came to me, I would tend to not look at it that way. I would want them to sit in the same room. I'd want to, I can remember a case, I won't call it an employment case, but I mediated a complex partnership dissolution. And I was able to sit with these folks who really did not like each other. There was hatred there. But by questioning them, I came to find out they were, boyhood friends, and one went into business and the other joined the business, and their wives were friends and their families were friends. And this event just shattered the entire structure of that. And when I started calling back on those types of issues and thoughts and feelings, these people were able to get past the, I can't stand your face, I don't want to hear from you. And they were able to strike a deal that was actually very commonsensible and worked for them, and the thing was done. That's not likely to happen in the kind of mediation that I sit in regularly as an attorney advising and representing.
So do you think this trend towards not even having a joint meeting is more driven by the mediator being uncomfortable with the conflict of the parties in a single room, or do you think it really is driving to a higher success rate in mediations?
Well, I wouldn't attribute a higher success rate to that technique, because it clearly is a technique. But I would say that the mediator at some level is saying, I'm really not willing to even risk a breakdown here. Now, I will say, in fairness to those mediators, there is often a party to the litigation who expresses a discomfort. I'll have a client who says, I was sexually harassed by somebody at the company, and the HR person who's attending, and maybe even the harasser, is sitting in that other room. I really don't want to see that person. Well, look, using my model, for example, I would agree at some point, if you're very uncomfortable, you're not willing to break down that, set of issues, maybe make something transformative out of it, then I have to honor that you don't want to do that. But again, it seems to me, it's sort of like, interestingly, my thought would be, how litigation presumes that 98% of the people can't work with each other. That's why we have to separate them or have them in a court where nobody's allowed to talk unless they're called upon, etc. That everybody needs to go see the principal, basically. And we really know that's not true, because it's exactly the opposite. Only really 2% or less do. Well, now we're looking at mediation in the employment law setting, and maybe others, where people are saying 99% of you can't sit in a room together. I just think that sends a terrible signal. And that's my clear, strong you know, op-ed perspective, but I do feel like I don't call myself a transformative mediator per se, but I have seen a lot of transformation come out of a well-done mediation with parties who didn't get along and may not get along in the future, but at least they know they can sit in a room together and be civil and make progress.
So what percentage of the cases involve an employee versus the company where the person is still an employee and will be an employee after the mediation?
What I see, they're mostly cases involving government employees, and there are a lot of those. You know, it's maybe an exaggeration, but it's anecdotally, it seems like an average of one claim per employee per career is on the low side, because some of them have 7, 8, or 10, and they use it sometimes as their own form of power or bargaining. And they'll file a claim of, here's my grievance. I've been discriminated against for fill in the blank reason. And after that, I was retaliated against. And then when I went for a promotion, I was turned down, which was further indication of retaliation. And these things can stretch themselves out over a long period of time. Those folks are, unless they do something absolutely rancid, they're in a bubble. You know, because every time management comes down hard, they just add that to the list.
Mm-hmm.
So this is certainly, I do a lot of federal sector employment conflict resolution, whether internally to the EEOC or even in federal court. And these folks can be going on 6, 8, 10, 12 years with this string effect of various complaints that have gone on. And when they come in to see you, it's not a party. You're looking at, you know, bank boxes and files worth of these types of complaints.
All right. How would you define what a successful mediation is?
Well, I would say I would look at that in 2 levels. One would be, what's the outcome in terms of dollars and cents? It's symbolic and it's important. Another one would be, how is my client feeling as a result of that? Do they feel, if not vindicated, at least acknowledged that the problem that they were describing actually has been recognized in some significant way, shape, or form? And a third way, I would say, would be, the matter does not settle right then, but the pathway is laid to make it resolve at a later time. And if you get very close, but you're not done, then you've got some tracks laid down for some later conversation with the other lawyer, possibly the mediator, maybe a trial judge. I've had cases that go back to the same mediator at a later point in the proceedings, and we finish it.
Okay. So, but are there failed mediations where you just say this thing was just a failure?
The one area that I would call a gross failure would be where you feel that the other side showed up not in good faith. They showed up with, you know, no money, no authority to get it resolved, and they paint a picture of, well, yeah, we're here, but we're not really the people that need to make the decision, and, you know, kind of, you can see it, and the energy just drains out of the room. And what happens there, you know, I think of an expression taught to me by a Buddhist monk about life generally. His thought is, we're here to help each other. And if we can't help, at least don't hurt. And what I'm saying is that a mediation that gives the plaintiff, and I would say the same thing could go for a defendant, that gives either side the idea that we've wasted our time, that we took a step in good faith and were completely rejected without anybody telling us before the fact that, by the way, we're going to go through the motion here, but there's no chance this thing's really going to settle now.
Right.
That's adding insult to injury. It makes people rageful, you know, just not just disappointed or frustrated.
So let's talk a little bit more about the mediators. Are there things that you wish mediators in these cases would stop doing that they are doing, or start doing things that they're not?
Well, on the stop doing what they are doing, many times mediators, without asking whether we want it, will become very evaluative and sort of in a no-nonsense way say, look, you know, for me as plaintiff's counsel, your client, and the client is sitting right there, really doesn't have a big chance at getting X, Y, or Z. I'm sorry, I just don't see it. If I did, I would tell you, but I don't. Now, they'll then say, and I assure you, I will be telling the other team the same thing when I spot their flaws in their case, and maybe they are. I would prefer a more what I would call organic approach to it. You know, it's sort of like in a way, when you first meet somebody, just you've never met them before, and the first thing they say is, "You got to trust me on this." Like, why? You know, that's a big ask under those circumstances. And I think that in some ways the mediators are using their own experience that they've had that maybe worked with some people, and they're just kind of broadening it like it's a tool they're going to use for everybody. It doesn't work well for me, and I mean, my clients don't necessarily like that. Now, there have been times in the past, I can't say so much recently, where I felt strongly enough that I would, you know, call the mediator, maybe the mediation is still happening, and say, this mediation is at risk. You're doing something that's actually really aggravating my client, and I have to say I don't blame them, and just explain that. And sometimes they're gracious and say, oh, then I won't do that. You know, other times they'll, you know, listen, and, you know, and then also I'm going to say it depends on the background of that mediator. Is this a retired judge who's, you know, probably going to be a more seasoned neutral and may have a certain kind of a fixed way, but I don't want to paint that brush too broadly, because I've had very senior retired judges as mediators who are extremely careful about the way that they treat the lawyers and the parties. They're very solicitous. They will ask, they'll say, do you want my point of view about something or other? You know, so I guess what I'm saying is that what mediators should stop and think about is, first of all, has the groundwork been laid before I start coming in with my, let me tell you how it is? And secondly, do the parties really want that?
Okay, now let's turn it around. Let's say, okay, you're the mediator. What were the things that you would want lawyers to stop doing?
Well, that's an interesting question, because like I say, so many of these are done with the lawyers in the other room and in this room. I can't say they're misbehaving, or that they can't say that I am. You know, we're not seeing each other, and maybe that's part of the reason they're doing it. I don't know. It cuts down on that conflict, absolutely. You know, I'm generally speaking, I would say I don't love posturing by either side. There is a certain gamesmanship to it, which I follow also. Many negotiators will say, who feel like they're being giving good advice. If you want 100x, you better ask for 300x, so you have some room to move down. Well, that's common sense, and I think that's not aggravating. What I would say more would be people characterizing my client in a certain way. You know, kind of like they call them names. They say they're a dirtbag or a scumbag, or they know what they did, or they're a criminal, or anything like that. You know, that to me, that's horrific. That should not happen. You know, they can be factual. That's okay with me. You know, your client misreported income here, you know, didn't do the protocol on a bank deposit or whatever it may be. But, you know, to just sort of avoid that naming and then calling of names on people.
So the mediators that you've used most, have they been retired judges, or are they more just practitioners, legal practitioners?
In the employment area, I've probably, I don't think I've ever used a retired judge. I'm willing to do it. You know, it depends on who shows up on each other's lists. That's pretty much what it is. I'll say, here's 3 names. They'll say, here's 3 names. And if I see a name on their list as somebody who I trust as a neutral and has the experience that I want, I'm going to say, oh, we'll pick so-and-so. And if it's a judge, it's a judge, you know.
Okay. Let me remind everyone that they can use the chat function if they want to submit a question. What does an average, if there is such a thing as an average employment mediation cost?
It's in the low thousands of dollars to say $5,000. You know, a lot of these that I've done they don't take more than a day. I could clearly see them going more than a day, depending on how complicated the legal issues are and the factual issues, as well as, you know, the attorneys need to do their presentation, do their argument, etc., to the mediator. Sometimes we can encourage, as a part of the negotiation, that the company will pay for the entire cost of the mediation. That does happen. Or a disproportionately large amount.
Mm-hmm. And you said they last usually not longer than a day, right?
Yeah, we try. I feel like it's good to get them done in the shortest period of time that you can. That's reasonable. You know, I want to go back to the issue of they're in their separate rooms.
Right.
The party, to get to a place where an employee or a former employee is willing to file a suit. Some people think, you know, that's no big deal. It is a big deal. It's going to take a lot of their time, especially that's especially relevant if they got a new job. They're going to be taken away from the new employment to go deal with this other one. They're very aggravated. You know, now sometimes the employer will say, well, it's self-designed, it's their problem, there was no issue, whatever. But let's just say at the level of perception, a lot of times the worker wants to be heard. So the mediator is coming into our space, and there's me and the client and the mediator. All the client can do is say, I feel really bad and hurt, and here's why. And I say to the mediator, could you take that back to the other team? Well, they're not there. So that whole venting aspect where people used to say, or still do in some cases, this is your day in court. It's the equivalent of it. You know, emotionally, let's deal with what is. That's all missing. You know, so the only thing that you have is the satisfaction of saying the matter's been resolved quietly, privately, with a non-disclosure provision, and I'm getting recognized as having been hurt because I got X dollars or X tens of thousands or hundreds of thousands of dollars in the settlement. That's something, you know. I'm not saying that's lacking in and of itself, but it would be better, in my opinion, for people to be able to sit together, reason it out, even if they're separated from at different points, but just to come together at the end and say, you know, thank you for acknowledging this. Thank you for cooperating. Occasionally I have that opportunity. Sometimes I even ask permission to do it if it's important to my client. And we do that. And sometimes the mediators look surprised, like, why do you need to do it? Why do you want to do it? Does the other side want to do it? But it usually works out pretty well. You know, then people can leave and not feel like I can't ever see that person in a store or on a bus without feeling like I feel shamed or that they should feel shamed by it.
Okay. Now, if we define success in the mediation as it's really resolved whatever issue or issues there are, what percentage of employment mediations that you've been a party to are successful?
Most of them, the vast majority. I would say you know. I mean, I'm talking not a huge sample, but let's say 10 to 12 over the past 6 years or so. You know, I can think of 2 or 3 that didn't go anywhere. And there were reasons that didn't go anywhere, but the rest of them settled. Now, some of them don't settle for big amounts of money, you know, but that's fine. I mean, it may well be that the facts don't bear out upon inspection some of the theories that the client had, or the document exchange shows, even in a limited document exchange, there's a gap, you know. But the interesting and important thing from my point of view, which has sort of sold me on the benefit of it, can you imagine, let's say you settle a case for $15,000 that's not a great case. As a trial lawyer, I would have dropped that case. I couldn't go to trial for that. I would we reserve the right in our engagement letters with these clients in these cases to not pursue something if we feel like there's not going to be a reasonable result. And you don't take a case for a $15,000 result after 2 years. We'd be putting in, you know, $75,000 worth of time to get a result like that. And the answer is going to be, I'm sorry, I can't afford to do that for you, client. So essentially, it's sort of like back in the days we looked at employment arbitration as, is that a good idea, a bad idea? This kind of mandatory arbitration, which is now pretty fixed in the law if the employer offers it and the client doesn't say no to it. The idea there was distributive justice. You get, you know, sort of smaller awards, but they're further spread across the turf. And I do find that, you know, these are not jury verdicts. These are where I did a civil rights matter probably 6 months ago. It was a very, very nasty case, very difficult, terrible relationship, you know, sexual harassment towards one of the employees, and the other one suffered a physical injury on the job and was fired, you know, almost immediately. So there might be a workers' comp dimension there, but there's also a civil rights issue. So we had this thing, and it was going on for a year, more than a year. Excuse me, Tabitha, can you close my door, please? I want that door closed. Thank you. So we went through at least a day of mediation. And I guess we had one of the people who's recognized as one of the top employment mediators, because an aspect of the case was employment related. And there was a company that we were suing. A day's mediation where my clients, honestly, they wanted $1 million for what happened to them. They were both completely overwhelmed with their terrible experience and how evil this fellow was, etc. And that case settled for $50,000. And I was surprised by that. I didn't think the employer was going to pay a penny, and I didn't think my clients were going to drop their number to make the thing work. I was surprised by that, but it was actually a great surprise because it took a very complex case off my desk that was going to take years and a lot of money, which they could not afford to pay even for discovery, to kind of tease out all of these subtle facts and depositions and all the rest of it. And, you know, I didn't make a lot of money on that, but they were happy. The other side seemed okay, and I was thrilled. It was a case that I could see going badly, you know, for a very long time. And sometimes there's not enough to justify staying in, but it's not terrible enough to justify pulling the plug either. And this way, mediations basically saved both sides the day.
Do you see employment mediation as a growing field, or is it static, or what?
I think it is a maturing field in the sense that it's no longer brand new. It's been around for at least a decade that I can remember. It's a tremendously growing field, and in that there are more and more employment disputes, and there's more statutory rights that get recognized, by the legislature, some common law causes of action. It's a big field. It's a major league big field.
Okay. Is there anything else you'd like to add? We're at the end.
Well, I would just say employment law reminds me a lot of family issues, because in both situations, the emotions run high. People bring their families in their heads to the table as they deal with issues of disappointment, betrayal, rage, etc. I remind people the idea of going postal, where somebody does physical damage in the midst of a rage over something, that did not come out of family law. It's basically almost like domestic violence in the workplace. And so the mediation world is a way of helping to calm those troubled waters. When lawyers are doing a good job for the management side and the employee, we're working on the same function to get it resolved and create a win-win outcome, with the understanding that not everything settles, and sometimes you need a jury or a judge to make the final decision. It's a challenging field, and I'm glad that I'm doing work in that along with my family law work, and I commend it to those who are interested in mediating it.
Well, thank you very much for spending the time today. I enjoyed talking with you, as I always do. So,
Carl, excellent questions. I appreciate it.
Okay, take care.
You too.